a written response to that motion this afternoon. Mr. Sullivan, do you have a copy of the Commonwealth's response?
They handed me several motions here, if I could inquire the government. So yes, they're nodding that they gave it to me.
Well, have you reviewed it? Are you prepared
No.
to address that motion?
No.
I have a suggestion on this motion, if
Yeah.
I may, if it's agreeable to counsel. Both sides have been working rather amicably together on these discovery issues, particularly involving scientific evidence. Although we did file a response and indicate the particular items that we object to providing as being overly broad and burdensome, I am hopeful that if we have an opportunity to speak not only to counsel but to the criminalistics personnel in the various labs, that we may be able to confine or narrow the issues that we have disputes on. Perhaps there will be no issues of dispute. My suggestion to the court, if it's agreeable to counsel, will be to advise the parties to do just that. And on the 20th, when we have our next hearing, we can argue any disputed requests for discovery.
Mr. Sullivan?
That's agreeable.
That's fine. I'll be happy to give you folks till the 20th. What I don't want to find is that on the 20th, I issue orders that then cannot be timely complied with, such that it might affect the date of disclosure or the trial date. I mean, the defendant has to get the material in sufficient time to make good use of it. But if you folks feel that you might be able to resolve most, if not all, of the issues, and I do see here in your response, Mr. Hagan, that you've agreed to a good deal of what is being sought, that would be fine. Mr. Sullivan, is that appropriate?
That is appropriate, Your Honor.
And Mr. Hagan, where you indicate you've agreed to some of the requests, does that mean you agree to provide, or does that mean you've already provided and therefore...
Unless we followed up, Your Honor, with the indication that we will inquire further, which we did, I believe, on perhaps 3 of the items and materials were requested. If we say agreed, it's been provided.
How many labs are you dealing with?
Only 2, well, depends whether you count our out-of-state expert. If you count his laboratory, there would be 3 labs, and that's just state police, the Boston Police Department, and the lab of our expert, Mr. Hagan.
I'm sorry, that was Boston Police. Who else?
Massachusetts State Police,
Yeah.
Boston Police, and the laboratory of our civilian expert.
All right. I have the defendant's motion in limine to exclude testimony on firearms analysis and expert testimony, or the terms that are used in expert testimony. If I read this correctly, it's a motion principally advanced or signed by Attorney Baden. Ms. Baden's not here today, correct?
Yeah, correct, Your Honor.
Is anyone speaking to this today?
Yes, I'm Mr. Leontine.
Okay.
Thank you, Your Honor. Your Honor, we've been having discussions with the prosecution with respect to submitting this motion on the papers.
Yep.
And we just received a responsive memo. We intend to respond to that memo and then submit it finally to the court for a decision on the papers.
Can you have a response in 10 days?
Yes, sir.
All right, then let me order that any response to the Commonwealth's opposition be filed by December 16. Based on what has been submitted by the defense, it is all in paper form, as is the Commonwealth's opposition. And it seems, at least in the first instance, that it can be ruled upon on the papers. If I determine that there's a need for an evidentiary hearing, then we can address that on December 20.
And Your Honor, we would respectfully request that this ruling is on the whole area of ballistics, and we will intend to readdress this issue as a Daubert hearing later on before trial, once we get whatever additional final evidence we have.
Tell me about that.
Well, we view this motion as a motion encompassing the entire science of ballistics, not just any subdivision of ballistics. And we think that there are specific areas within the ballistic realm that we think we're going to have, depending on how Your Honor rules on this motion, that we're going to need to have a Daubert hearing on. I can't tell you specifically yet because we're still working with our experts, but I just didn't want the court to think that this was in lieu of a Daubert hearing.
I view this as a Daubert request.
I know Your Honor, you said that before.
I had that discussion last time you folks were in,
Right.
Telling Ms. Baden that she is challenging the science, if there is any, to comparative firearms analysis testimony, and she is challenging the methodology that is used and the validity of that so-called science, and that is classically what Daubert and Canavan and in Massachusetts Lanigan are focused on. So it seems to me the issue is framed. If you're telling me that if I rule that this testimony or this type of science is admissible in Massachusetts, then you may have motions in limine relating to the scope of the testimony.
That's correct.
Then I don't know that that's necessarily a Daubert as opposed to a motion to either limit or preclude certain types of testimony.
Now, I understand the distinction, Judge, but let's assume for a moment that we have a dispute with respect to the science of a subset within ballistics and whether or not that is acceptable or not. We still think that there is the potential for a Daubert hearing on that issue.
Well, why wasn't that filed then?
We're not at that stage. We're contesting the entire validity of ballistics testimony generally. And within ballistics testimony, there are a variety of ballistics testimony encompasses a great deal. And we can't...
No, in this case it doesn't. It encompasses a fairly discrete set of issues and proffered facts, if I understand it. The Commonwealth claiming that a firearm was recovered, that a projectile recovered from the homicide was connected to that firearm as a result of a ballistics analysis or analysis of the projectile compared to some test fire.
We have not made that argument, Judge, with respect to the analysis of that projectile in these documents. We are going to intend to make that argument at
Well, please understand, I'm ruling on this because I consider this as a live issue at this trial. It's a live issue only because it ties into the Commonwealth's anticipated forensic evidence.
Oh, I agree that it
I'm
does.
not ruling in kind of free form.
No, I understand that, Judge. I just don't think that this motion, which challenges the realm of ballistics generally, should preclude a hearing on the specific expert testimony and the validity with respect to a specific ballistic issue.
All right. Let me make this very clear so that we're not confused at all. To the extent there is a motion to limit or exclude evidence, that motion must be timely filed. I thought I had already set filing dates. You apparently didn't feel that they applied. You filed one motion challenging the so-called science or methodology of comparative testimony, a testimony of comparative analysis of, in this case, firearms evidence. That's fine. I'll rule. To the extent you have any follow-up motion, that motion must be filed timely such that it may be heard and decided, permitting a sufficient time under the Massachusetts rules for you, if decided adverse to your interests, have time to file for interlocutory review. And that time period is set by rule. I will not delay the trial date in this case because there is a late filed motion that results in an adverse ruling to which either side then seeks interlocutory relief and claims that they need further time either to prepare their pleadings or the necessary time to have it reviewed and decided. That's all a way of saying that to the extent you intend any further motions, Daubert related or otherwise, that may lead to some interlocutory review or request for that review, those motions should be filed by December 20 and no later. And I don't mean to put too much time constraints on you, but it is necessary that we set whatever dates we have to set so that this case can be teed up to be tried starting February 13th.
I understand your ruling with respect to the issue, Your Honor. Thank you.
All right.
May I be heard briefly, Your Honor, just to clarify
Yep.
the ruling. So I understand with respect to the Daubert issue. So this, the pleading in front of you, we are not submitting it as a Daubert issue. I understand the court's response.
You think it isn't. I think it is.
Correct.
Okay.
With respect to the ruling about
Because between the two of us, who wins?
Oh, the court always. But having said that, for purposes of the record, I'll still state that we do not consider this a Daubert. With respect to the December 20th date, and with respect to this forensics issue, that's fine. We just received 3 discs of discovery that I haven't looked at, so I cannot make a blanket representation that I can have anything filed by the 20th without even having looked at what I just received in court today. I didn't know if Your Honor's ruling was intended to apply globally to all issues here, and if that's the case, my simple point is we don't know the scope of issues at play yet, in as much as there's things that we just received.
Well, let me say this, Mr. Sullivan. I think we all anticipate there will be trial-related motions that we see in the normal course, whether it's motions to admit or preclude or motions in limine that generally do not require evidentiary hearings and are not terribly complicated. And I'm not imposing December 20 as a date for those rather garden variety trial-related motions.
Very well.
To the extent there is something in the discovery that you've just referenced, with 3 discs of material, that is new to you, if you get an opportunity between now and December 20 to at least review the discs so that you're in a position to alert the court if there is something new there that is a surprise that warrants additional time. And we can then set dates for those new materials and newly disclosed information.
Very well.
Okay. All right, so on the defendant's motion in limine to exclude ballistics or firearm analysis evidence. The Commonwealth's opposition having been filed the other day, the defendant now has 10 days to file its response to the opposition, and upon receipt of that, the motion will be taken under advisement. All right, I have the defendant's motion to suppress relating to a claimed violation of the attorney-client privilege leading to the Commonwealth filing an affidavit in support of a motion in support of a search warrant for that telephone. I have that. I think the Commonwealth has today filed a response or opposition to that motion. Is that correct?
Yes, Your Honor.
It seems to me that the motion to suppress ought to give rise to an evidentiary hearing that I would plan to conduct on December 20. Mr. Sullivan, of the defense team, who will be the laboring oar on that motion?
I shall labor away.
All right. Do you contemplate witnesses?
Yes, we do.
Including the individuals named within the motion?
Yes, Your Honor.
Okay.
And that's one person out of state.
All right. That would be the so-called sports agent?
Yes, or lawyer.
Or lawyer. Okay. Commonwealth, do you contemplate witnesses?
Yes, Your Honor.
All right. Can we plan on that hearing taking place on December 20?
Yes, Your Honor.
Do you folks contemplate that we can deal with that in one day, or is it more than a one-day hearing?
I think we can do it in one day, Your Honor.
Mr. Sullivan, does that sound right to you?
Sounds right to me, given our side, so I think so.
Okay. Then we will have that evidentiary hearing on December 20, or commencing December 20, and hopefully get that done in one day. Now I have the Commonwealth's motion for in limine regarding an in-court identification. Let's make sure we're all discussing, speaking in the same terms here. The motion is filed by Mr. Hagan, Ms. Anderson, Mr. Smith. I can't quite tell. That scribble represents whom?
That's me, Your Honor.
That's you, Ms. Anderson. If I understand what you're telling the court, you intend or wish or seek permission to have a single in-court identification by a non-police witness, that being Mr. Bradley.
Yes, Your Honor.
That with regard to other individuals, the two other passengers in the vehicle, or three other passengers in the vehicle, you do not intend to ask any of those individuals to make an in-court identification. Is that right?
Correct. We will not seek an in-court identification from those witnesses.
And none of those witnesses have participated in an out-of-court identification procedure.
Identification procedure? No. They have made out-of-court identifications.
You do not intend to elicit those?
We may, Your Honor. That's not the subject of this motion. And the defense has not moved to exclude those out-of-court IDs. That's our position.
Have you given notice that you intend to introduce those?
We have given notice that we are not agreeing that we will not introduce those IDs.
Let me see counsel here at sidebar.